Hi everyone, this is a video on the European Convention on Human Rights and the European Court of Human Rights as well. So by the end of this video, you should know why the European Convention was created, how the European Convention on Human Rights is enforced, how the European Court of Human Rights works, how the European Convention is interpreted. We're going to have a look at the doctrine of proportionality and the margin of appreciation in relation to qualified rights. And we're going to have a look at some key cases to show the effectiveness of the European Convention / the European Court of Human Rights. So throughout this video, I'm going to refer to the European Convention on Human Rights either as the European Convention or just the Convention. Okay, let's have a look at the history of the Convention. So the European Convention on Human Rights was created by this group called the Council of Europe. The Council of Europe was set up in 1949 with the aim to prevent another European war. So this was set up just after World War II. So their aim was to stop authoritarianism in Europe following Nazi Germany and Adolf Hitler, and to reflect the aims of the newly created United Nations. A further aim of the Council of Europe was to protect democracy and the rule of law, hence the creation of the European Convention on Human Rights in 1950. So this convention reflected the liberal Western states that were responsible for drafting the convention. One such state was Britain. British lawyers were involved in drafting this, so it does reflect our values. And in this convention, it includes civil and political rights. The European Convention includes absolute, qualified and limited rights. So your absolute rights are things like your right to life, freedom from torture, freedom from slavery. Your qualified rights are things then like right to a private life, freedom of expression. These need to be balanced against each other. So we're going to have a look at proportionality and margin of appreciation in a second. And limited rights as well. So these are things like right to a fair trial. They can be moved away from in certain circumstances. Okay, so how is the European Convention enforced? So you can enforce the rights in the European Convention against public bodies only. So these are things like the NHS, the police, could be the prison service, any public bodies. It can't be against a private individual. So that links to Section 6 of the Human Rights Act as well. It's very important to note that this is nothing to do with criminal law, it's a civil law procedure. So you sue the public body for a breach of human rights. So if they have interfered with your human rights, you sue them in civil law. Therefore, you are seeking compensation or any other remedy. So it could be a change in policy. That could be the remedy that you want to avoid any further breaches of human rights. So before the Human Rights Act in 1998, obviously the Human Rights Act allows individuals in the UK to go to domestic courts if they feel their rights have been interfered with. But before that, you would apply to the European Court of Human Rights in Strasbourg for your case to be heard. It is important to note, though, that there are some rights that can be derogated from or moved away from. These are not the absolute rights, except for the right to life in certain circumstances, but it does include your qualified and limited rights as well. So Article 15 allows the state to derogate or move away from their obligations under the Convention in time of war or public emergency threatening the life of a nation. So a case example of this is A and others. So in this case, it was that the government tried to move away from an individual's right to liberty. So A and others were detained, and the government said that they were able to detain this group of people because they were a threat to the life of the nation. The European Court of Human Rights noted in this case that in emergency circumstances which can justify derogation, the national authorities have a large margin of appreciation. We're going to have a look at margin of appreciation in a bit more detail later on in this video, but it means that the court would defer to the state to a significant extent. They would allow the state to make the decision. They feel like the state is in the best place to make the decision whether it's right to move away, to derogate from the obligations. However, in this case, it was found that because the House of Lords previously noted that the measures taken by the government were not strictly required, they went a bit too far, they weren't proportionate, the European Court found that the derogation wasn't lawful and that their actions, the state's actions, went too far. Okay, so now we know that the European Convention on Human Rights can be enforced against public bodies. We have to know about the European Court of Human Rights and the structure of it. So the European Court of Human Rights is situated in Strasbourg in France, and it is the most developed regional international court for human rights. So it can examine either interstate complaints, so states between two different party states, so say France and the UK, or it can hear applications from individuals. So if an individual's rights have been interfered with by a public body, they can bring a case to the European Court of Human Rights. So it is the primary enforcement mechanism of the European Convention on Human Rights. So now we do have the Human Rights Act in the UK, where you are allowed to go to a domestic court. However, the right to appeal to the European Court of Human Rights has not been removed. Therefore, it is your final point to see whether your rights have been interfered with unjustifiably. So one of the negatives, and this is an evaluative point now, is that because it's accessible to all individuals within the Council of Europe, there's about 47 member states, it means that there are many, many applications, creating a huge backlog of cases. It takes approximately 6 years for a case to be heard. So it is a long time for a case to be heard. But let's have a look at the structure then. So we've got a single judge first. So a single judge only rules on the admissibility of applications. We'll have a look at admissibility in just a second. And it will say whether a case is admissible, whether it's allowed to be heard in court, or inadmissible based on the material submitted by the applicant. If it's inadmissible, then it won't be heard, it won't be decided upon, it will be, for want of a better word, thrown out. We've then got the committee. So the committee is composed of 3 judges, and they also rule on the admissibility of cases, but they also look at the facts of the case and they look at the merits of the case, where the case concerns an issue already covered by well-developed case law. In this, the decision must be unanimous, so it must be all 3 judges who rule whether there has been an interference or whether there has not been an interference. We then have the chamber, and this is composed of 7 judges. So the chambers primarily rule on admissibility and merits as well, but these are for cases that raise issues that have not been ruled upon before or repeatedly. A decision in this case may only be made by a majority, so it doesn't have to be all 7 judges. So each chamber includes the section president and the national judge, so the judge with the nationality of the state against the application is lodged. So you've got a single judge, just admissibility, your committee, which is admissibility and merits, where those cases have been heard previously or similar cases. The chamber then is 7 judges, admissibility and merits, but on cases which have not been ruled on repeatedly. And then you've got your grand chamber. This is your main one here. So this is composed of 17 judges, and the grand chamber usually hears a very small select number of cases which have either been referred to it on appeal from a chamber decision or relinquished by a chamber. So if it's a very important or novel question where it has not been heard before, the application will go to the grand chamber. It would never go directly to the grand chamber, it would be referred to from the chamber, for example. They would never rule on admissibility, they'd just look at the merits of the case. Okay, once a decision has been made, it would then go to the Committee of Ministers, who would then communicate the decision back to the state. So let's have a look at the admissibility criteria very quickly. So an applicant has to get through the admissibility stage before the merits of the case. As I said before, so a single judge, committee, a chamber would all have a look at whether it is admissible or not. If it is admissible, the committee, chamber, or grand chamber in very serious cases would then look at the merits of the case to see whether there was an interference of human rights or not. In order to get to that stage, though, the admissibility criteria is set out as the following. You have to be a victim of the interference. You have to be directly affected by the act complained of. All domestic remedies must be exhausted. So now, because in the UK we have got the Human Rights Act, you'd have to go all the way up to the Supreme Court in order to exhaust all domestic remedies. Your application has to be within 4 months of the final decision of the domestic court. So once you have gone all the way up to the Supreme Court, your application to the European Court of Human Rights has to be done within 4 months of that decision. It cannot be an anonymous complaint. You do have to identify yourself. It cannot be substantially the same as a case already examined by the court. So say, for example, you have already sent your case to the court and it was seen as inadmissible. You can't then send it again, maybe with some more information and hope that it's seen as admissible. They don't allow that. It cannot be incompatible with the convention, such as being out of its jurisdiction. So obviously, if it was, say, for example, America that interfered with your rights, a public service in America, you can't bring that to the European court. It cannot be manifestly ill-founded, so it can't be based on illegitimate information, for example. It cannot be an abusive process, and significant damage must be suffered. So this significant damage was introduced to try and reduce the caseload, because obviously previously there have been many cases coming through the European Court or to the European Court. So this significant damage tries to reduce the amount of cases that get through the admissibility stage. Okay, let's have a look at interpreting the convention. So the convention is known as a living instrument. So the role of the European Court of Human Rights is to interpret the convention rights, and this application of the convention then be followed by member states. With your revision, you should be having a look at the Human Rights Act in Section 2, which says that due regard should be made to the decisions of the European Court of Human Rights. So the court itself, because it is an appellate court, is the top court, it's not bound by precedent, but it should consider previous decisions. So it's open to a dynamic interpretation which allows it to develop human rights protections in an ever-changing society. You have to remember this was created in 1950. Now in 2022, society is very different, okay? We have become more accepting, we have become more liberal as well, and it is important that the convention reflects that. So the European Convention has been described as a living instrument by the court. So in Tyra and UK, it was held that the European Convention must be interpreted in the light of present-day conditions. So this means that the court is prepared to change its findings on many issues as society changes. We're going to have a look at some cases to do with this then. The first case we're going to have a look at is Rees and UK, which was in 1981. So all three cases that we're going to have a look at are to do with transgender people. In this case, the applicant was transgender and wanted to change his name on his birth certificate, which he was not allowed to do by the UK government. He argued that this was a breach of his right to privacy. The court in this case held that attitudes towards transgender people varied state from state, so the margin of appreciation was applied widely. So it gave the discretion to the UK to say, you know what, you do what you think is best for your country in this situation, and therefore found no violation of the right to privacy. In then Cossey and UK 1991, so 10 years later, once again, applicant was transgender and was not allowed to change her sex on her birth certificate, which would then allow her to marry a man legitimately. It would not allow a valid marriage with a man if her gender was male on her birth certificate. Obviously, gay marriage laws have changed now, but this was back in the 1990s. So the court was asked to reconsider Rees based on the living instrument principle, but found that despite the developments, there was still not enough common ground to do so. So there was no violation of the right to privacy here, or the right to marry either. So still in Europe, there wasn't a consensus, there wasn't this recognition of transgendered people and their rights. Fast forward then to 2002, and then we've got Goodwin and the UK. Once again, applicant was transgender and argued her right to a private life was interfered with because the government did not allow her to change her birth certificate to be recognised as female. In this case, however, the court recognised the social and scientific changes across the Council states, so did find a violation of Article 8. There was a consensus now across the party states that transgender people should be recognised as the gender that they are transitioning into. So it was a violation of Article 8, not allowing her to change her birth certificate to be recognised as female. So there have been positive changes through this living instrument principle, reflecting society's views. So margin of appreciation, I've talked about it a lot. What is it? So this is a doctrine that considers the amount of discretion or choice given to a state by the European Court when adjudicating or deciding on alleged violations of qualified rights. Only qualified rights would the margin of appreciation come about. So this doctrine is based on the fact that the state is primarily responsible for upholding the convention rights, and there may be variations in tolerance of measure in each state. I believe in the UK we are a very liberal country and we do have a high level of tolerance, but there are other member states which may be less liberal and therefore have a lower tolerance. This principle of the margin of appreciation was outlined in Handyside and the UK. And it was said, by reason of their direct and continuous contact with the vital forces of their country, state authorities are in principle in a better position than the international judge to give an opinion on the exact content of these requirements. So essentially it's saying that the countries, the states are in a better position to decide what's best for their country. So there are some key cases for this. The key cases show the difference between a wide margin of appreciation and a narrow margin of appreciation. It's never predictable as to how the margin of appreciation is going to be applied, but there are some cases which we'll have a look at in just a second. So if there is a wide margin of appreciation, it means it's less likely to find a violation. The court is less likely to find a violation, where a narrow margin means it's more likely a violation will be found. So let's have a look at a wide margin case. So Pretty and the UK. So Diane Pretty, a very famous woman, she suffered from motor neuron disease and wished to end her life at the time of her choosing. She wished to take part in assisted suicide or euthanasia. However, in the UK, that is a criminal offence. It still is a criminal offence. It has been debated in Parliament, but it still is criminal. Pretty argued that this interfered with her Article 8 rights. The European Court in this case disagreed with Pretty and decided that the margin of appreciation in her case should be very wide and it should defer it back to the UK Parliament. In this case, it wasn't a decision for the European Court to make because it would affect the state, it would affect the UK and its laws, and would do so quite drastically as well. However, a case which shows a narrow margin of appreciation is Dudgeon and the UK. In this case, Dudgeon was homosexual and he alleged that the existence of laws in Northern Ireland which made homosexual acts between two consenting adults criminal offences violated his right to a private life. In this case, there was a narrow margin of appreciation because it concerned the most intimate aspects of private life. So there must be particularly serious reasons for interferences into private life. So therefore, in this case, a narrow margin of appreciation was found and a violation was then found because this was to do with the very personal life of individuals Pretty, on the other hand, would then affect the whole laws in the UK. So they're two very different cases. Proportionality then. So this is a tool used to find the balance between the rights of individuals and the community, once again deciding upon qualified rights. So the criteria the court will examine when looking at the act or measure of the state in question include: is effective, so does the act meet a legitimate aim? Is there a link between the interference and what the state argues it's meant to be achieving? So, for example, if we have a look at the right to privacy and phone tapping, and an individual is possibly a terrorist and the government wants to tap their phones, wants to listen into their conversations, they could argue that doing so would meet a legitimate aim of protecting the public from a terrorist attack. Is it the least intrusive measure possible? Could there be any less intrusive measures put in place? So, for example, phone tapping would be quite, it is intrusive, but less so than, for example, there being a bugging device on their front door, which would listen into all their conversations. Does it deprive the very essence of the rights? So does the act take away all the protection of the right or merely limit the right? If it takes away all the protection of the right, it would not be seen to be proportional. However, if it just limits the right, then it was likely to be seen as proportional. And is it balanced? Has there been a fair balance struck between the competing interests of the individual, such as the right to privacy, and of the community as a whole? Okay, let's go on to the effectiveness of the European Convention on Human Rights, or the European Court of Human Rights. It's kind of both. So the European Court has noted on numerous occasions that the Convention needs to guarantee rights that are practical and effective, in that the individuals are able to access the rights laid down in the Convention, and that those rights are enforceable. If the rights are not enforceable, then obviously there's no point having this Convention to protect our rights. So a case example of this is Golda and the UK. In this, the applicant was denied access to a solicitor whilst in prison. We know now under PACE this is not allowed, but this is 1978. So this is pre-PACE. So in this case, it was held that Article 6, a right to a fair trial, must also be read to include access to a court or access to legal advice. Without this, then the protection under Article 6 and then Article 5, the right to liberty, become redundant. There's no point having the right to fair trial if you don't have access to a solicitor or legal advice. The rights in the Convention, as I said before, are civil and political rights, which are usually negative rights. Negative rights mean that the state has to not interfere with your act. It requires the state from refraining to act in a way that violates the right. It doesn't require the state to act. However, the European Court has interpreted the Convention in a way that places a positive obligation on states. So it requires the states to take positive steps to prevent violations of the Convention. A case example of this is Osman and the UK. So in this case, it considered the right to life, and the court noted that Article 2 does not only obligate states to refrain from taking a life, to not take a life, but it should also take the appropriate steps to safeguard lives within its jurisdiction, so within where a law applies for it, where the state knows or ought to have known at the time of the existence of a real and immediate risk to life, and have failed to take measures to avoid the risk. So it's important that if there is a threat to life and this threat is known and this threat is real, that the public authority, whoever it may be, usually the police, should take steps into protecting that right, that life that is at risk. Some key cases you can have a look at to show, we've had a look at Goodwin and Golda, for example, but if you follow this link here, go into Amnesty International's website and find out the European Court cases that have made us safer. There's lots of different cases on here. You can do your own research for that. We've got sad face up here. There is one thing that's not so good about the European Court of Human Rights. Just going back to what I said before, when the court delivers a judgment finding a violation, the court then will give, so the chamber, for example, or the Grand Chamber will give a file to the Committee of Ministers. The Committee of Ministers then communicates with the country and decides how the judgment should be executed and how to prevent similar violations. So that's a good thing, okay? It works with the country to prevent further interferences with human rights and breaches of human rights. So this results in general measures, especially amendments to legislation and individual measures where necessary. This is all very good. However, some decisions made by the European Court, such as allowing prisoners the right to vote in Hurst and UK, have not been implemented. The Committee of Ministers have asked the UK to implement this decision, but no action has been taken. So enforcement is not as clear as it should be, or is not as forceful. Okay, let's have a quick summary about what you've learned today. The European Convention on Human Rights was created by the Council of Europe in 1950. The European Court of Human Rights is the primary enforcement mechanism of the European Convention. The Convention is seen as a living instrument, which means that the court is prepared to change its findings on many issues as society changes. So a case example of this are Rees in the UK compared with Goodwin and UK. The European Court of Human Rights can give states either a wide margin of appreciation for situations they believe is best for the state to deal with, or narrow margin of appreciation where the situation is more private or personal and the state shouldn't be involved with it. This is only when there has been an interference of a qualified right. When there is an interference with a qualified right again, the court has to decide whether the interference was proportional to the aim it was trying to achieve. There have been many key decisions which have improved our rights. Make sure you do your own research and find out which ones that you are interested in that you can include in this kind of essay. And some decisions by the European Court have not been acted upon by the UK, which may limit its effectiveness. So that's an overall summary of the European Convention of Human Rights and especially the European Court of Human Rights too. Hope it's helpful. Any questions, give me a shout. Thank you. Bye.